Good afternoon, everybody. Thank you for joining us for the Kickoff webinar program in Conn Maciel Carey's 2018 OSHA webinar series. We're so excited to see a lot of familiar names joining us again from folks who participated in the past, and a lot of new names who are joining us for the first time. We have a lot of fun with these webinar programs, but we're giant OSHA nerds. We hope you enjoy these programs as well, and I think we've got a really great kickoff event today. It's something we do every year, is sort of take a look back at what we learned about OSHA from the year that just ended and forecast a little bit about what to expect in the upcoming year. Really exciting thing about the period we're in now is that there's a lot of change. We've moved from the Obama administration to the Trump administration, and we had a fairly full year under the Trump administration, but this will be the first upcoming full year under the new administration, and perhaps the year when we see some of the seats in the leadership at the agency filled. So we will start to see what the agency is going to look like over the balance of the Trump administration. So that's what we're going to talk about today. One of the other exciting things that I enjoy about this annual program that we put on is that rather than just hearing from one or two of us, we've got pretty much our whole team together to present today. And without eating up a lot of everybody's time, with everybody introducing themselves and going through their full program, I'm just going to share a little bit very briefly about our practice. This is Conn Maciel Carey's National OSHA Practice Group that will be putting on the program today. The first voice that you're hearing right now is Eric Conn. I'm the chair of the OSHA practice here, and I've practiced for more than a decade, for 18 years in the OSHA field, and for more than a decade alongside the first general counsel of the OSHA Review Commission before starting my own practice and then starting this firm that specializes in OSHA work. I'm very pleased to be joined today by the full national OSHA practice at Conn Maciel Carey. My partner Amanda Walker, who is a presidential appointee at OSHA prior to moving into private practice. Kate McMahon, a former advisor on the Hill and a really true expert in health standards and rulemaking. Micah Smith, a PSM guru. My partner is Andrew Summer, who leads our Cal OSHA practice out in San Francisco, and Aaron Gelb, who's just joined the firm, and I am going to let him introduce himself more fully today, because we are very excited to be announcing on this webinar that we have launched a Chicago office and moved Conn Maciel Carey to have a big footprint in the Midwest now, with a terrific OSHA lawyer and employment lawyer, Aaron Gelb, leading our OSHA practice in the Midwest. And when his time during this program begins, I'll have him introduce himself in a little bit more detail, because you've not heard from him before. And then, of course, our two rising stars, our great OSHA and employment associates, Lindsay DeSalvo and Dan Deacon, joining us today as well. So we're real excited to kick off this year's program, real excited that you all could join us, and I know this is going to be an interesting discussion. So as I said, we're going to review what we learned about OSHA in 2017, and we're going to sprinkle that throughout today's program. A lot of it's going to be in this area, whether it's enforcement, rulemaking, regulation by shaming, and public announcements by OSHA, those sort of things. We'll talk about what happened in the year that has now passed and what you can expect in those areas in the year to come. And, you know, we set it up to basically be our top 10 list, and it really was, you know, we had a hard time planning for this program because there is so much going on, so many changes we've already seen, and so many more that we expect this year and in the years to come. But we set it up as a top 10 list of the key issues that we're going to track in 2018. And you see that list here, and we're going to go through all of those. But we'll start off with one thing that I know our participants enjoy, is looking at some of the data and bigger developments that occurred at OSHA in the year that has just passed. So let's take a look back at 2017, which was really the first year of the Trump administration, although there has been quite a lag in the Trump administration really getting its fingerprints at OSHA and really taking hold and implementing its agenda. And that sort of is really visible in the data that we're going to talk about. First thing that we usually report on is total federal OSHA inspections that occurred during the year. And this is, and it's a fiscal year number, so this does include a little bit more overlap even of the Obama administration into the Trump administration. But one of the really fascinating things about this data is that the number of inspections was trending down pretty consistently year over year during the second term, really for the most part for all of the Obama administration. It spiked at the very beginning, and then essentially every year fewer and fewer inspections were conducted for a variety of reasons. There was a government shutdown, there was sequestration, there was some resource restrictions at OSHA, as well as a different approach to how the agency focused on and valued inspections, looking more for quality inspections, more man hours per inspection, those sort of things. So they were doing more complex inspections, which was driving the inspection number down. Then lo and behold, the first year of the Trump administration, when everybody is forecasting, you know, it's all about deregulation. It's all about killing agency rules and killing agencies and moving away from enforcement. And this was the first year that we saw an uptick, not a big one, but an uptick in several hundred more inspections conducted in 2017 than in 2016. So, you know, take away from that what you will. My view of it is we haven't really seen the impact of the Trump administration on OSHA yet. We don't have their leaders in place. You know, the political appointees, particularly the assistant secretary for OSHA, no chief of staff, and so it's really the career OSHA folks running the show with a little bit of direction from the administration. And so with the career folks, you wouldn't expect to see a lot of major change from what things looked like during the Obama administration. And here, sort of surprisingly, even a little bit more inspections than in the past. Despite having a few more inspections than we saw in 2016, the total violations number did continue to trend down. And this is, again, a trend that's been continuing throughout the Obama administration. There was a big spike in the beginning, and then it's dropped a little bit each year. I think that goes hand in hand with fewer inspections, also somewhat hand in hand with the big spike in penalty authority. You know, it could be that OSHA was deliberately cobbling together more violations to get penalties up to a more a level that might discourage bad conduct. Well, now with much higher penalty authority, which we'll talk about a little bit today, you know, more than an 80% increase in penalty authority from 2015 and beyond, that may have an impact on why there's fewer violations issued. So that's an interesting statistic there. One statistic that I report on every year, despite the fact that it rarely ever changes, because it is such, in my mind, such a significant statistic about OSHA inspections, and that is the percent of inspections that result in 0 citations, what OSHA calls an in-compliance inspection. And that means OSHA shows up, they're at the right place, they actually do an opening conference, and they conduct an inspection. In those circumstances, there is about a 75% chance every year that at least one citation is going to be issued. And that, you know, shows you a little bit about how hard it is to go through an inspection clean. You hear those stories about the inspector in the field saying, look, I've got to find something to prove to my boss that I was here. And the data fleshes that out, right? There's not 75% of workplaces out there are bad actors. It's just that it's extremely difficult to go through an inspection without a citation, single citation being issued. We did see that number tick up to 27% in compliance, but that seems to be within the margin of error and really not much of a notable change. So it remains a difficult task. One thing that we did see, again, an enforcement statistic that would defy the general theme that, you know, Trump administration will mean less enforcement, will mean employers have less to worry about from OSHA, and that is the average penalty per violation. We always use the serious average penalty as a benchmark for what it looks like across the board. And here we see, and it's no surprise that you saw a big jump in 2015 and 16 and 17 as the new penalty authority was implemented, right? We went from $7,000 maximum penalty per serious violation up to in that $12,000 to $13,000 range. So with that new authority, everything sort of bumped up by about 80%. The minimum penalties, the average penalty, and the maximum penalty, and that's why you saw, essentially almost a doubling of the average serious penalty between 2014 and now 2017, as that penalty amount, the maximum penalty amount, continues to climb. So, again, another data point here to show if we're all expecting that things are going to change dramatically as we move to the new administration, that may not be the case. This could be a reflection of the career folks more or less running the agency for the time being, or it could be a sign that, we're still going to see significant enforcement regardless of which administration controls the White House. This data point was the one that was sort of most surprising to me, although when you think about the new penalty authority, it shouldn't be, and this is the cases where the total proposed penalty was $100,000 or more. It used to be called the significant cases. What OSHA considers a significant case has gone up significantly as the penalty authority has gone up, but we still do, as an apples-to-apples comparison, $100,000 cases. And this year, 2017, again, it's fiscal year, so it includes a chunk of the Obama era, as well as a period where there really was no political leadership at the agency, so really it's the career OSHA folks running the show. And here we saw the highest number ever of cases with total proposed penalties of $100,000 or more. 60 jumped up by about 40% from where it was in 2016. So that's a big jump, significant, and shows you that at least right out of the gate we did not see a dramatic change in the way enforcement was handled at the agency. And you've heard me say now a couple of times, well, we'll talk one more data point here, and that's the $1 million cases. We did see a little bit of a drop off there in the per year $1 million cases, but it's still 3 times as high as it was during the Bush administration. Fiscal year 2017 had, and this is not a definite number. We used to base this number on the press releases. There was a period where press releases were cut off, where OSHA was not issuing them. So this is an estimate, and we're trying to confirm what that number was with OSHA. If I get that number, I'm happy to share it. But we were seeing about $8.5 million cases per year during the Obama administration. We saw, my estimate is 6 last year. So, one of the things you kept hearing me say was, we can't really necessarily point to what happened in 2017 and say that's what things are going to look like over the balance of the Obama administration. The reason is we haven't seen the full political leadership, political appointed team in place there, and that's what my partner Amanda Walker is going to talk about as I hand things over to her.
Good afternoon. Hi, my name is Amanda Walker, and I'm a member of the Conn Maciel Workplace Safety Group, and going to talk a little bit about the leadership changes at OSHA that drives the initiatives in the direction of the agency. As with any office change, when a new president is elected and you have a change of party, you see new leadership at OSHA. The thing that's been particularly unusual about this year is the pace at which they're getting in. At this point right now, OSHA only has 1 political appointee. There's about 4 or 5 spots that are usually filled, that were filled during the Obama administration as well as the Bush administration, and now we're well into a year of the new administration, the Trump administration, and we only have 1 individual, 1 political at OSHA. So that's a little unusual, and that individual is Lauren Sweat. He was the key OSHA person on the House Ed and Workforce Committee over in the House, helping the committee that had jurisdiction over the subject matter, was kind of the point person there. She's been there since about July, and she is currently acting Assistant Secretary of OSHA. Prior to working on the Ed and Workforce Committee, she was with a trade association in the D.C. area. The other individual who has been announced with regards to the second political appointee that is going to hopefully be in the door sometime soon at OSHA is Scott Mugno. He's VP of Safety at FedEx Ground, has been very active in the safety and health community, participated in Chamber of Commerce committees on this subject, as well as a number of different panels and organizations related to safety. He has been nominated. His nomination came out in October of 2017. He has had a hearing before the Senate Help Committee. All DOL nominations who are of the Senate confirmed level have to have a hearing. He has had a hearing, and he has made it out of committee on a vote one time before the Christmas holiday. And now, since he did not get a vote in the full Senate, and that was largely due to scheduling issues and a variety of different issues taking a higher priority in the Senate, he now has to go back through the committee vote. So he is back waiting for a committee vote to get out of committee to then go to the floor for a full Senate vote. He was scheduled to have a committee vote last week, but all of a sudden it was postponed at the last minute, and it's not been rescheduled at this point. There was some discussion about it taking place this week, but just looking at the calendar, there's not been anything posted with regards to that, and we're also hearing a lot of discussion about a budget shutdown. So there might be other issues taking higher priority this week, and it might not happen this week. So we don't really have a clear indication when he's going to get out of committee, and then he also has a second round to go for the full floor vote. So really hard to tell when he's going to be in the door. It is unusual for it to take this long for a political appointee, the Assistant Secretary of OSHA, to be confirmed. In the Bush administration, the first Assistant Secretary was in, I think, by late summer of the first year of the administration, and during the Obama administration, we had the Assistant Secretary in place by December. So this process is running a little longer than probably just about anyone anticipated, but it is still moving through the process. And those are currently the two political leaders at OSHA. Also, too, with the shift to balance of power, we're seeing a different makeup at the OSHA committee. OSHA is the administrative agency that reviews contested cases and issues orders. It is made up of 3 commissioners, and it's been quite a while since we've had all 3 of those commission spots filled. Typically, the party in power at the White House has 2 of those spots, and then the 3rd spot goes to the party out of power. So now that we have a Republican president in the White House, we now have 2 Republican-affiliated commissioners that have been nominated by Trump, and that is Heather McDougal and James Sullivan. Both of them came from private practice where they did deal with OSHA cases. Heather's down in the Florida area, and James Sullivan is from the Pennsylvania area, and he is the most recent addition to the OSHA Commission. They did get their confirmations through the Senate probably in the August timeframe, and so now we have a fully staffed OSHA Commission, which is something we haven't had for a number of years. Cynthia Atwood is the Democrat, and she has been on the commission for, I think, since maybe 2010, was reappointed by Obama, but she's been there a number of years, and she comes from Department of Labor, where she was involved in the legal side for OSHA, one of OSHA's attorneys in the solicitor's office. This new makeup of the OSHA committee is pretty interesting. We had the first oral argument in 7 years last week, so it seems as though this committee is ramping up and should see some exciting decisions from them. One of them could be very pivotal in the construction area, whether or not a construction standard was appropriately adopted when OSHA had authority under 7A of the OSHA Act to bring in industry standards. So some interesting decisions and likely outcomes that with this new makeup of the OSHA Commission. There's other personnel changes, just not at the top level and at the commission, but all throughout the OSHA ranks. Seeing quite a number of retirements in the career leadership ranks. In June, Dorothy Doherty, who was the Deputy Assistant Secretary, retired, and that position is yet to be filled. They've had a number of different individuals in an acting capacity there, but it's not been permanently filled. We have just seen one regional administrator depart, retired, Greg Baxter from the Denver area, and there's a couple others that speculation has it that they're close behind. Also seeing some directorate heads. We've actually got two directorate heads. One is in the training office and one is in the whistleblower investigation office that are unfilled and in an acting capacity. And there's also speculation there that some other folks are going to be departing as well. So just an interesting change. Don't remember so many departures within OSHA at the high levels. And that's not even speaking to the area directors and other levels. Definitely have seen some departures there. And just to put some perspective on the numbers, since January, I think there's been 116 staff members. The number of staff members at OSHA have gone down by 116, and it's roughly a 2,000-person agency or employee agency. So a pretty significant number. OSHA is getting particularly some news has been covering the fact that we're down, or OSHA's down 40 inspectors. That is a 4% decrease in the first 10 months of the Trump administration. There's been, OSHA's said that they've hired several new COSHOs since that October timeframe, but they have yet to release the numbers. And these trends are something we're seeing all across the federal government. Just in the first year, or I don't know if it's the first year or first 10 months, but looking at 16 fewer permanent federal employees. So this trend certainly going on throughout the industry. Talked about the number of COSHOs down 40 COSHOs across the country for OSHA, and that could be somewhat attributed to the hiring freeze that was in place, but that hiring freeze has been lifted, and hopefully there will be some replacements, or maybe not in the COSHO inspection area, but in other areas within OSHA. And I think that about does it for my section. So I'm going to be turning it over to my next colleague.
Thanks, Amanda. This is Micah Smith, and I get to walk you through the deconstruction portion of this presentation. If you heard one thing in 2017, more than anything else, it was probably that the Trump administration is going to slash government regulations. It was a campaign theme back in 2016. It was a common complaint among congressional Republicans all throughout the Obama administration, and it was also one of the clearest early themes that we saw in the Trump administration. This was best stated last year around February at CPAC by Steve Bannon, Trump's erstwhile chief strategist. When he gave this quote in blue, he said, "Deconstruction of the administrative state. The way the progressive left runs is if they can't get it passed, they're just going to put it in some sort of regulation in an agency. That's all going to be deconstructed." There's been no clearer statement of what we've been expecting out of the Trump administration than this. So we saw this right around the time that Mr. Bannon made this statement. We saw a lot of activity that seemed to confirm this. A lot of activities from EPA, the Department of Interior, especially right at the outset of the Trump administration. We saw what looked to be some strong actions from the administration to try to tear down what had been created not only in the Obama administration, but even from prior administrations. We didn't see the same thing from OSHA, but we'll talk about some of the reasons for that in just a minute. One of the biggest early deconstructive acts came not from the administration, but more from Congress. We saw the Congressional Review Act being used for nearly the first time in history. It had been used once before to kill one of the last rules out of President Clinton's OSHA, but Congress and the Trump administration used it to kill 14 rules in early 2017. They got two OSHA rules here, we call it the Volks rule for record keeping, and then also the FAR, DOL, Fair Pay and Safe Workplaces rule. This is fairly remarkable, not only because it was 14 instances of use of CRA, whereas it had only been used once before. It also happened fast. So we have these statements from Steve Bannon in February 2017. We have EPA and Interior actions in early part of the year, and we have Congress starting to tear down portions of the Obama administrative legacy that had been put into place. So we see a lot of early actions here with CRA taking a high profile early in the year. Another big signal was in Executive Order 13771, which is the 2-for-1 regulations. I think we've all heard about this, that if any agency wanted to get a new rule out, they were going to have to cancel 2 of the old ones. We'll talk a little bit more about this in a second, but this was another clear signal back in January that the Trump administration intended to really try to roll things back. We saw this tendency, this push continue when the administration released its first 2 versions of its regulatory agenda. One of the most clear signs there was the fact that they renamed it. It wasn't the regulatory agenda anymore. It was now the Unified Agenda of Federal Regulatory and Deregulatory Actions. So all of a sudden, rather than seeing this as a regulatory document, it included deregulation in its stated purpose. On the OSHA front, we saw a number of rules, I think it was more than 10, moved either to long-term actions. Those are going to be the rules on the right, including workplace violence and PSM rule reform. And then others were just simply removed from the regulatory agenda. That's the items on the left. So that includes updates to chemical pills, things that hadn't been updated, many of them for 20 or 30 years or more. So we see a lot of delays here in the first year of the Trump administration, trying to slow things down. Now, having said all of that, where are we? If we're keeping score, we see 2 OSHA rules canceled by CRA. We see a handful of delayed or canceled rulemakings for OSHA, and an executive order that's going to put conditions on new rulemaking. That's a pretty fair amount of activity in the first year of administration. And I don't want to minimize the importance of those changes. But remember, we were promised deconstruction, right? We were told that we're going to roll back the regulatory state, we're going to push everything away. But yet, if we look today, there have been no notices of proposed rulemaking issued by OSHA to rescind existing rules. Every rule that was pushed out before in the Obama administration before 2016 and by every other administration is still in place and still being enforced. So why is that? There's a few obstacles that are pretty obvious to deregulation in OSHA, and the first one, I think we've already mentioned it, is missing political appointees. Without an assistant secretary and other top-level officials, you have the career folks running the agency. Not only do they not feel empowered to make big changes, they're probably career OSHA personnel who believe heavily in the mission and in the rules that they've pushed out there before. So that's a big obstacle. The other big obstacles come straight from the OSHA Act and what Congress did when they created OSHA. So we've got a few quotes here that are important, and one of the first ones comes from Section 6B. The Secretary's power to make or rescind new rules comes from this section, and it says you can only do this to serve the objectives of the Act. Well, what's the objective of the Act? You see that in Section 2B, where Congress declared it to be the purpose and policy to assure, so far as possible, every working man and woman in the nation safe and healthful working conditions. So you see that one of the conditions of not only promulgating a new rule, but also revoking or modifying an old rule is to serve those purposes, to assure safe and healthful working conditions. So you have to ask yourself, what if OSHA decided, as part of the Trump agenda, to revoke a rule for economic growth reasons? Could they do that? You don't see that in the purpose of the OSHA Act. It doesn't seem to be something that was on Congress's mind when they created OSHA. So if Trump's OSHA tried to push this deregulatory agenda in this way, you might see some very fertile ground for a legal challenge. Now, I won't go into much more detail here, but I think it's worth asking yourself if you think that we're going to see a lot of deregulatory action. Could OSHA demonstrate that an existing standard, make it PSM, Lotto, HAZCOM, any of those things that really affect employers nationwide, could they demonstrate that those standards are not reasonably necessary and appropriate, or that their choice to destroy or revoke one of those isn't arbitrary and capricious? That's going to be the standard that the Trump administration will be held to in litigation if they do start trying to roll back these rules. So call me a cynic, but I have to say that I'm not real optimistic about how easy this will be for the Trump administration to start rolling back rules. One final point is look for the silica standard, the beryllium standard, to maybe serve as case studies for deregulatory efforts. These were very late, rules issued very late in the Obama administration. They are targets of industry. There's a lot of complaints about the content of those rules, how they regulate employers' conduct. So watch for changes here. On the silica standard, it's pretty important to note that while we've had challenges filed in the courts by industry and labor, the OSHA has allowed the construction silica standard to go into effect. It is now in full force and is apparently being enforced by compliance officers. The general industry standard has not come into effect yet, but we're looking at a deadline of June 2018, and we've seen no movement by OSHA yet to try to delay that any further or to start some kind of a rollback. On the beryllium side, we did see some moves by OSHA to pull this back, and there is an ongoing industry challenge and negotiations among all the stakeholders. You could see this is one way that OSHA could actually accomplish modifying or rolling back a rule by getting everyone involved to sign off on it. But we'll see where this ends up. So I'm going to be watching these two standards, and I'm also going to be looking for that first notice of proposed rulemaking to see if the administration is actually going to start rolling back some old rules. And with that, I'll kick it back over to Eric for the next section.
So interesting discussion there. That was sort of the overarching view of what's going on from a rulemaking standpoint with OSHA. We're going to talk about two specific rules that we do expect to see some action in 2018. And it's sort of a mixed bag, just like Micah's discussion was a mixed bag about things that were repealed in the first days of the Trump administration, some delays and some other things that were moved off the active agenda, but really no deregulation, no rescinding, no revoking of rules yet. The two things that we're really paying attention to in 2018, or that I'm going to be paying attention to in 2018, is first a rule that is advancing through the rulemaking process and has actually been moved into the final rule stage, and that is a rule that will affect lockout-tagout. And my colleague Dan Deacon's going to talk about the injury and illness electronic record-keeping rule that may have a different fate. It may be the first one where we see an NPRM to either revoke or to amend to narrow some regulatory requirement. First, let's talk about lockout-tagout. This is I believe, the only item that was moved into the final rule stage during President Trump's first two regulatory agendas, and you won't find it under a header of lockout-tagout because it's actually an effort that's been ongoing, initiated by the Obama administration to try and slip a major lockout-tagout rule into a program called the Standards Improvement Project in a way that I don't think is appropriate. The intent of the Standards Improvement Project is to make minor changes, non-controversial changes to confusing, conflicting, or outdated requirements. They are supposed to be minor and non-controversial. And in the current iteration of the SIP, the Standards Improvement Project, SIP 4, there is a proposal to basically write out of the lockout-tagout standard the key language, unexpected energization. That is a qualifier for when work needs to be done under lockout-tagout. It is when hazardous energy is unexpected. And the reason why OSHA is proposing to do this is they're trying to basically overrule a court decision that they don't like from several years back. And here's the context of that. Again, the lockout-tagout standard applies when there is service and maintenance of a machine or equipment in which unexpected energization could start up a machine and harm an employee. The standard doesn't define what unexpected energization is, so it was left to the Review Commission and the courts. And the Sixth Circuit in 1996 issued a decision that seems very intuitive to me and correct, but OSHA doesn't like it. And that decision said that the term unexpected energization unambiguously renders the rule inapplicable to situations where an employee is alerted or warned that a machine that they're working on is about to activate. And therefore, lockout-tagout isn't required under this standard if energization is expected, and those circumstances include if an alarm gives clear, audible, or timely warning before a machine is going to start up, or if an employee who's performing service on the machine, the controls are located such that he will be aware that the startup of the controls have been activated. It's a small machine, or the work is being done in a place where he has obvious visual and continuous access and visual link to where the controls are. And similarly, if equipment is unplugged and that plug is exclusively in the control of the employee providing service, those circumstances can't be unexpected energization. And if it's not unexpected energization, lockout-tagout is not required. OSHA promulgated this slipped into the SIP-4 rule, writing out of the rule unexpected energization. So it's basically any energization that could cause harm, whether it's expected or unexpected. And while there may be good justification for that, it ought to undergo its own rule. It should not be slipped into the Standards Improvement Project. So I'm going to watch to see what happens here in this next year under the Trump administration. It moved from in the works into the final rule stage, but my guess is that happened before the Trump administration really understood what was in that SIP-4 proposal and understood the significant change that might be coming to lockout-tagout. So I would not be shocked to see, as the full political team gets in place at OSHA, that they change direction on that. But I also wouldn't be surprised, with it being the only rule in the final rule stage, that it does get finalized. So that's something I'm going to pay close attention to in 2018. And one more rule Dan's going to talk about here.
Thanks, Eric. This is Dan Deacon, and I'm going to talk to you briefly today about OSHA's Injury and Illness Electronic Record-Keeping Rule. As you may or may not have heard, the agency is currently drafting a notice of proposed rulemaking. The extent of what that rulemaking is going to entail is largely unknown, but there's a couple things that we anticipate going forward. So I'm just going to go over really quick some of the notable provisions of the rule and then what we can expect in 2018. So this rule has been around for quite some time now. It was first published back in May 12, 2016. And there are several notable provisions that sparked some industry backlash, including anti-retaliation provisions related to injury and illness reporting procedures, post-incident drug testing, and safety incentive programs. And then there's this new requirement to electronically submit your injury and illness data through OSHA's online portal known as the Injury Tracking Application. And there are two major provisions related to that electronic data submission. And the first one there that you see on the screen is establishments with 250 or more workers must annually submit OSHA 300 logs, 301 reports, and 300A summaries by the deadlines. And two, establishments with 20 or more workers in a high-hazard industry must also submit the 300A annual summaries on an annual basis. So as I mentioned, there are these certain anti-retaliation provisions that were included in there as well. Specifically, as of December 1st, 2016, employers were required to inform employees of their right to report workplace injuries, inform employees of their right to report work-related injuries free from discrimination or retaliation, and 3, update injury reporting policies to remove unreasonable elements that can discourage employees from reporting. And those included discipline for late reporting, bag safety rules, blanket post-injury drug testing, which is prohibited under the rule, and safety incentive or compensation programs that are directly tied to injury rates. So these provisions were largely in response to complaints to the notice of proposed rulemaking initially that the rule would lead to underreporting or under-recording. So OSHA actually supplemented the rule to include those elements specifically. So here, this slide is just some of the key reporting deadlines that have actually changed quite a bit over time. The original deadline to submit 2016 data was originally July 1st, 2017. However, that deadline was pushed back to December 1st, then again to December 15th, and then ultimately to December 31st, 2017. The next deadline, as you can see, is quickly approaching. It's July 1st, 2018. So we got about 6 months or so, a little less than 6 months. But what we do know is that there's currently a notice of proposed rulemaking that's being drafted. So that deadline may change when that notice of proposed rulemaking rolls out, and we'll see what happens with that. What we do know now is that OSHA has updated its website indicating that large establishments, so those establishments with 250 or more employees, are not going to be required to submit their 300 logs or their 301 forms, the 301 reports by that 2018 deadline. So that is the one notable change that we know is definitely on the books right now. Also, I want to touch quickly on state plan states and their adoption of the E-Recordkeeping rule. This is one important element that employers really need to be aware of. So state plan states are required under the OSHA Act to promulgate injury and illness recording and reporting requirements at least as effective as federal OSHA. And with respect to that data submission requirement, FedOSHA basically granted states some flexibility in how to collect that injury data and when to do so. So most states are opting to use OSHA's injury tracking application, but to this date, some states have still not finalized their own version of the record-keeping rule. So right now, if you're in one of those states that you see on the screen, California, Washington, Maryland, South Carolina, Wyoming, Utah, Minnesota, Vermont, right now the rule is not in effect in those states and you do not need to submit data. Actually, the injury tracking application won't even let you submit data if you are an establishment in one of those states. So going forward, what can we expect under the anti-retaliation rule and the E-Recordkeeping rule? OSHA recently updated its website, as I mentioned earlier, that covered establishments with 250 or more employees are only going to be required to submit their 2017 Form 300A data. So they're not going to be accepting their 300 logs or their 301 forms at this time. Again, OSHA announced that they're going to be issuing the Notice of Proposed Rulemaking to reconsider, revise, or remove provisions of the E-Recordkeeping rule. The extent of those changes are still unknown, so we're going to have to wait and see what comes of that, which we expect to be out sometime in the near future in the next couple months. But for right now, July 1st, 2018 still is the current deadline for the next data submission for 2017 data. So we know that this is a priority for the administration under President Trump's first and second regulatory agendas. The new rulemaking to rescind or amend the E-Recordkeeping rule is actually included on those regulatory agendas. So what you see here on this slide are some of those changes that we expect and are hypothesizing that may occur. So the first is injury data limited only to 300-day annual summaries, and that's already a given pretty much. It's been posted on OSHA's website, and it doesn't appear that that's going to be changing. Two, they could increase the threshold trigger for high-hazard industries. So under the current rule, OSHA used the average DART rate across all industries and said that anyone above that average DART rate was going to be classified in the high-hazard industry. So this was somewhat of an arbitrary metric and not a reliable way of really determining who or what is a high-hazard industry. So we may see them use a higher DART rate figure to classify who would actually be considered in a high-hazard industry. Three, they could increase the threshold for small employers to be covered. So increasing that threshold trigger for high-hazard industries from 20 or more employees to something maybe along the lines of 50 or 100 is going to significantly decrease the burden on a large number of employers. And finally, the fourth bullet that you see there is eliminating the anti-retaliation provisions. There's a lot of backlash from employers about some of these provisions, and there wasn't a whole lot of guidance on those issues. So we anticipate some of those are going to get a major overhaul and clarification from the new administration. So next, I'm going to turn it over.
Yeah, we're going to shift up the order a little bit and talk about, as our fifth item on the top 10 list, the potential for criminal prosecutions continuing in this administration.
Good afternoon, everyone. This is Kate McMahon. It's good to talk to everyone today. I want to spend just a few minutes really talking about criminal prosecutions under the OSHA Act and other statutes for worker safety issues. I'm hoping that this, I won't spend too much time because we have a lot to cover, but I want to share for 5 or 10 minutes a little bit about what we've seen historically and what we expect to see under the Trump administration. Again, a little bit of a black box, but we have some theories that we formulated here about what might be going on and what we might see over the next few years. I do hope that what I talk about here over the next few minutes is very interesting to you guys, but also extremely irrelevant, and so I won't spend too much time. First, what I want to talk about is historically, I can't seem to move the, can we move the slides? Thanks. Okay. Let me just give you a recap on criminal prosecutions and criminal penalties under the OSHA Act for worker safety violations. As some of you may know, Section 17E of the OSHA Act does provide for criminal charges to be brought under a narrow set of circumstances for worker safety violations. In order to bring a criminal charge as opposed to a civil charge, two key elements must be present. One, there must be a fatality. An employee we have to have a worker death. And second, we have to have a willful violation of a requirement of, an OSHA regulation. And so both of those provisions have to be met in order to even bring a criminal charge under the OSHA Act. If that is brought and if those elements are met, the charge under the OSHA Act is a misdemeanor charge. It is not a felony. It's fairly limited, at least compared to some other statutes I'm going to talk about in a second. In terms of the punishment, you can have imprisonment up to 6 months and a fine for $250,000 for an individual or $500,000 for an organization. So that's the most you can get on the OSHA Act. Historically, we've got a slide here that shows you that we had approximately 500,000 fatalities since the Act was first passed in the early 70s. Only about 80 criminal referrals, and out of those, only a dozen criminal convictions over the entire stretch of the OSHA Act for the last 45 years or so. We have seen over the last 5 years or so, 5 to 7 years, a trending upwards of criminal referrals to the U.S. Attorney's Office. And in particular, under the Obama administration, we saw a ratcheting up of criminal referrals. Now, this was done under the OSHA Act. There's a new policy that the Department of Labor enacted under Obama that said that every case involving a fatality and a willful violation, those two elements, must be communicated to the U.S. Attorney's Office. Obviously, that doesn't mean that the U.S. Attorney was going to bring a criminal charge for that act, and that did not happen, but there were more criminal charges brought under the Obama administration than there had been in many years because of this new policy. So what this means is there will be at least an opening of an investigation by a U.S. attorney where there has been this recommendation from the Department of Labor because of a willful violation resulting in employee fatality. However, the landscape did not change that much until we saw two new memos from the Department of Justice. These are referred to as the Yates memos. They were issued in September of 2015 and December of 2015. The first one that was issued in September of 2015 really did not have anything it had consequences in this area of worker safety, but it really had it was not driven by a concern about worker safety. This is a memo entitled Individual Accountability for Corporate Wrongdoing. It really resulted from the financial crisis and ensuing recession in 2008. As I'm sure we all know, no head of a bank, no head of a Wall Street firm went to jail as a result of the financial crisis. And the Obama administration reacted to that by developing a new policy that is designed to incent positive corporate behavior. And the way to do that, according to this new policy, is to really go after individuals, management individuals at corporations where there's been violation of the law. The agency believes, the Department of Justice believes that that a policy like this will deter future illegal activity. It will help change and mold corporate behavior in a positive way, and it will hold the proper parties responsible for their actions. Rather than letting a corporation, pay a couple $1 million and get out of a violation of the law, they're going to put the CEO behind bars for a few years, and they think that will really incent positive change. So that is the backdrop for another policy change that was issued in the form of a memo, again by former Deputy Assistant Attorney General Sally Yates, which was issued in December 2015. That memo, which relates to worker safety specifically, so right in our wheelhouse, that memo is designed to basically really force U.S. attorneys' offices that are getting these referrals to look at and seriously investigate under the OSHA Act criminal penalties, criminal charges where there has been a worker fatality and a willful violation. But also, and probably the take-home point from this part of the discussion is, this policy also says that the Department of Justice should look not only to the OSHA Act, but to environmental statutes, the Clean Air Act, the Clean Water Act, TSCA, RCRA, and also, Title 18, Section 18 obstruction charges that should be investigated where there is a worker safety violation. And that's done for a couple of reasons. The Department of Justice recognizes that under the OSHA Act, you only at maximum can get a misdemeanor charge, even if the government proves their case. 2, you can only do it where there's been a fatality. And so the Department of Justice really seemed to be, under Obama, redoubling their efforts, as a quote from the memo says, to hold accountable those individuals who, violate, jeopardize worker safety and health by using the tougher teeth of the environmental statutes in particular. And we have seen, in fact, we at our law firm have represented a number of individuals who are being investigated or for whom charges have been brought under environmental statutes for essentially OSHA-type violations. So that's something to really watch out for. Now, query, what is going to happen next? Under the Trump administration, is this Yates policy going to be dismantled? As I'm sure anyone who watches CNN knows, Sally Yates was not a favored deputy at the Attorney General's office by President Trump, and in fact, she's no longer there. However, we do have Attorney General Jeff Sessions, who's known to be a law and order type guy, and we also, I think, have something at work here. When you think about who President Trump's base is, his base are, blue-collar workers. One theory about what might happen here is, even if on the civil side there is some effort to deregulate, to support business efforts to have less, onerous regulations that impact the OSHA area, query whether the president and the administration might think to sort of insulate themselves from criticism for deregulating in an area where, where regulations are designed to protect the base by bringing some high-profile criminal actions. With Jeff Sessions at the helm, assuming he remains there for some time, tough law and order guy, they'll pick a few bad actors, and they'll use the environmental statutes, which have, much greater teeth. Felony charges, millions of dollars, many millions of dollars can be brought in criminal charges against individuals or corporations. So we anticipate that we might see sort of a heightened risk of criminal prosecutions, in part to insulate and provide cover if they're trying to do deregulation on the civil side. And we also have, we have Secretary of Labor Acosta and hopefully soon to be Assistant Secretary of Labor Mugno, who are both committed to, pursuing OSHA Act criminal cases in confirmation hearings. So all of those factors at play lead us to believe that while there may be some deregulation on the regulatory side, OSHA regulations, we likely will continue to see at least an even keel or an upward trend in criminal violations, and they're going to be high profile, and the government's going to rely on environmental statutes that have tougher teeth than the OSHA Act.
All right, thanks,
so
Kate.
I think that's what I wanted to say about that.
Appreciate it. I'm obviously glad to be joined by all my partners and colleagues on this program today, but I'm especially pleased to be joined by Aaron Gelb, who's going to cover the next couple of sections of the program, and that is because just within the last week and a half, 2 weeks, Conn Maciel Carey launched our Chicago office and added Aaron as a partner out in Chicago to lead our efforts to provide safety and health regulatory services to our clients across the Midwest. So I'm happy to introduce Aaron, and we'll ask Aaron to provide a little bit more detailed information, intro about himself than the rest of us have today because he's new and we're all excited to have him.
Thanks, Eric. I think we're on day 11 of the Chicago office, and I could not be more excited to join what I think is a truly amazing group of OSHA lawyers and open Conn Maciel Carey's first Midwest outpost here in Chicago. I'm sure that you're anxious to come out and visit us right about now in the middle of January. We'll try to warm it up a little for you. So I've spent the last 19 years of my career practicing here in Chicago after about 3.5 years at a larger firm in St. Louis. I attended college at the University of Chicago and law school at the University of Texas in Austin. While I've handled OSHA matters throughout the Midwest and beyond, covering a broad range of industries, I also devote a substantial part of my practice to defending employers facing discrimination and harassment claims in federal court, as well as before federal and local employment agencies. But I know everyone's dialed in not to hear about my background, but let's talk about some OSHA penalty levels. So as a threshold matter, it bears emphasizing, and I suspect that most of the people listening to the presentation know that the increase in the OSHA civil penalties is not the Trump administration's handiwork. Rather, as most of you probably know, this was done by Congress, which mandated a one-time catch-up in August of 2016, increasing penalties roughly by 80%, as Eric referenced at the beginning of the program, after they had remained the same for roughly 25 years. So serious citations, for example, we saw the max fine rise significantly from $7,000 to $12,471. Effective January 2nd of this year, the penalties have increased again, this time by roughly 2%. So that means that the max penalty for a serious citation has gone up from $12,471 to $12,934. Keep in mind that these penalties will increase every year going forward, tied to changes in the Consumer Price Index. So penalty amounts aside, what can employers expect from OSHA in year 2, year 3, and possibly year 4 of the Trump administration? We anticipate once new leadership is in place that the employers will see the mentality return probably more along the lines of what we saw in the last Bush administration, with more of the agencies having balance between enforcement and compliance assistance. We've heard in the public remarks of both Secretary of Labor Acosta as well as Mr. Mugno during his confirmation hearing that signal a clear shift in priorities. Now, you might be asking yourself, how can we predict such a change, given that Eric at the beginning of the program talked about all of the data that's showing more inspections and higher penalties? Obviously, as we already covered, that we have seen and we've been under the continuation of OSHA career people, and even though David Michaels left at the start of the year, those people were still running the show. Once Mr. Mugno is confirmed, we will likely see his agenda in short order, and we'll see what changes that he wants to make. Until those things happen, OSHA might not look that different, at least early in 2018. That said, we expect that OSHA will eventually revise a number of policies as well as certain parts of the field operations manual that resulted in inflated penalties. We also think that employers will see OSHA retire certain special emphasis programs, both the national emphasis programs and local emphasis programs. These programs that were used to direct enforcement resources towards high hazard industries or occupations that were perceived as posing greater risks of severe injuries or death. If you look at the numbers under the prior Bush administration, we saw roughly 4 or 5 national emphasis programs, but that number ballooned up to at least 12 under the Obama administration. Plus, OSHA under the Obama administration put out close to 100 regional and local emphasis programs. Now, we don't know which of those programs are likely to go away, but we are confident that a good number of them will. In short, employers should see a shift from a proactive, targeted enforcement under Obama to more of a reactive approach as we've seen in the past. Now, this does not mean, obviously, that you should ignore OSHA. And even if inspections are less frequent, even if the citations amounts turn out to be lower, and there are fewer ticky-tack citations. So, for example, I had a client that received, and perhaps some of you can relate to this, a $15,000 repeat citation when the COSHO found a single knockout panel was missing from a junction box. So what can we expect, since OSHA is not going away, is that sort of what we call the poster child enforcement, meaning if there is an employer that the agency finds that's ignored its responsibilities, that employer should likely expect to be hit and hit hard. Sort of to be an example for those folks that say, hey, we're not looking to jam you up, but if you're not doing what you're supposed to be doing, certainly if you're not doing that willfully, that you can expect some pretty heavy sanctions. One area where we hope and expect to see such a change is with respect to repeat citations. During the Obama administration, OSHA used repeats as a way really to flex their muscles, finding and citing repeats more frequently, and with those citations, obviously significantly higher penalties. While it was not unheard in the past to base a repeat on a citation issued at a different facility operated by the same employer, usually those were in the same area or at least the same region. But under the Obama administration, we came to see OSHA routinely treating each and every workplace in a corporate family as a single workplace. So you could very well see a repeat citation in Illinois based on something that happened halfway across the country. We also saw the look-back period expand in terms of what prior citations could be used as the basis for a repeat from 3 to 5 years. Meaning that employers now basically would have to go half a decade without a substantially similar violation or risk that costly repeat citation. When you couple that with the proliferation of the special emphasis programs, as we had employers subjected to inspections and subsequent repeat citations, even though they did not have another accident or generate further employee complaints. Now, if you look at the data in this slide, I think it's interesting. It confirms that these changes had, for OSHA at least, certainly not for employers, the desired result. The number of repeat citations increased as a percentage of citations every year. Between 2008 and 2016, the percentage increased from 3.2% to 5.3% of the citations. This is particularly significant when you consider the increased penalty amounts that enable OSHA to fine an employer nearly $125,000 per repeat. So under the Obama administration, 4 repeat citations could easily net an employer $500,000 if OSHA goes for the max on each one. So turning back to our crystal ball, what can we expect as far as repeat citations going forward? We anticipate the agency will revisit some or all of the changes that I've just discussed under the Obama administration. We may well see a return to the 3-year look-back period. As certain special emphasis programs are retired, we should see a return to more of the reactive inspections approach, and thus fewer employers being hit with repeats where there was no injury or complaint to prompt the follow-on inspection. We may also see the agency abandon the successorship analysis and return to the alter ego model. Now, this is something that was covered, I believe, in a webinar that we put on last November. But I think the significance here is that it makes it less likely, if OSHA does shift to that focus, that the agency could establish that a buyer would be essentially acquiring the seller's inspection history and citation history when they buy that company. Again, keep in mind that while change may be coming, it's certainly not going to happen overnight. So if there are employers out there that were inspected 3, 4, 5 months ago, you're nervously waiting for word from the area office as to whether they're going to go repeat. You're checking your mail for that's what you think may be a repeat citation. You may not see a change in these policies or these approaches that's going to benefit you at least immediately. In those instances, it very well may make sense to contest the citation and hope the winds of change blow in your favor going forward. All right, thank you. So now let's kind of shift gears a little bit and talk about compliance assistance and cooperative programs and what changes we expect to see there. While change has been minimal to non-existent to date on the enforcement side, we have seen already, at least in my view, a pronounced shift on the compliance assistance side. For example, if anyone regularly logs into the OSHA website, as Eric said, we're OSHA nerds, so I think we all do that fairly regularly. Those of you that don't, there have been some very obvious changes that have drawn public comment from former OSHA officials. For example, if you were familiar with the scroll that provided information about every workplace fatality, that's disappeared from the main page on the site. There certainly is, again, less of an emphasis on enforcement, and I know Eric's going to be talking about public shaming. If you subscribe to the OSHA's quick take emails, which I find can provide a lot of helpful information, the change in content and tone, at least from my perspective, was very noticeable and almost immediate. It was sort of like it happened overnight with a switch being flipped. I can remember the old quick take emails coming in with a heavy emphasis on major citations, employers that were bad actors were really called out. And now you see a heavy emphasis in those emails on cooperative programs, partnerships and alliances, training tools, et cetera. They still do include references to significant citations that have been issued, but for the most part, the number of enforcement stories has really been dialed down. I think on average, just from looking at past emails, you saw is 5, 6 citations described in the prior administration quick takes, and now we see on average more like 2 or 3. So with this increased emphasis and more attention being paid to compliance assistance resources, I think we're also going to see an increased use and reasonableness of the LOIs or letters of interpretation. As Micah had talked about earlier, rulemaking takes time, and we haven't seen any examples of that. So it's not really conducive to making a splash or affecting quick change. Just like we've seen under the Trump administration with the use of executive orders, look for the agency to issue LOIs to reverse course in certain areas where they want to make a quick pivot. I think it's also safe to say in this regard that we're not going to see any more of the Fairfax memos. So for those of you who can recall the now infamous memo that Richard Fairfax issued regarding incentive programs, we're certainly not going to see anything along those lines. We may also see OSHA more willing to grant variances. Historically, the granting of variances has been a rather rare occurrence. I believe one of the last general industry permanent variances was granted close to 2 years ago in regard to a modified lockout-tagout system for a steel manufacturer. Once the Trump appointees are solidly in place, the environment around and likelihood of success of receiving a variance may change, and it could well become a valuable tool for employers going forward. Last but not least, and I suspect there are probably a good number of folks that are interested in this as far as the voluntary protection programs. I've made a number of predictions today, but one thing we do know for certain is that OSHA is seeking to reshape and hopefully revitalize the voluntary protection programs. How do we know that? A public stakeholder meeting was held in New Orleans on August 28th of last year with the express purpose, it was included in the invitation that went out on OSHA's website, for the purpose of soliciting suggestions for growing and strengthening VPP. After the meeting, the agency accepted comments initially until September 15th and then extended that deadline into October. And I think if you look at what the agency, the areas in which it sought feedback, it's rather telling. So the agency asked what it could do to enhance and encourage the efforts of employers, workers, and unions to identify and address hazards through VPP. They asked how it could support increased participation in VPP while operating with available resources and maintaining the integrity of the program. We're certainly, that is likely going to be a challenge with the new budget. Once we kind of see where the money is going, it certainly can expect some impact, potentially reduced resources available to OSHA. They also asked how the agency could modify VPP to enhance the efforts and engagement of long-term participants, those employers that obviously had been committed to the program and involved for a long time, how the agency could modify corporate VPP for greater leverage and effectiveness, and further leverage participant resources such as the special government employees. If you've applied or been accepted into the program, you probably know why OSHA is taking this step. Under the Obama administration, OSHA really became quite hostile to the program. It was perceived, at least from the administration, as too easy to get into, too difficult to kick an employer out once they're in, and providing too much relief to those employers that were in the program when something went wrong. So while we don't know how quickly things will change in this area, those employers in VPP and those that aspire to be in it should find, and that's emphasis on should, the programs are more likely to provide the benefits they were intended to provide to both employers and employees alike. I think that is it for me.
Okay, so good afternoon. This is Lindsay DeSalvo, and I'm just going to now briefly run through, I know we're running a little short on time here. We have a couple sections left, so I'm just going to briefly run through the past and current policies on public shaming, as well as what we see might occur going forward. So the agency under President Obama found substantial value in using regulation by shaming, which was namely using press releases and other tools at their disposal to publicly shame an employer after the issuance of citations. So often at a point where they haven't actually proved the allegations and the employer hasn't really had a chance to respond. This slide shows a quote from the former Assistant Secretary of Labor for OSHA, David Michaels, which explained the impact that the agency hoped public shaming would have on employers, as well as shows where he coined the term regulation by shaming. So when it comes to the Trump administration, there does seem to be a different approach being taken here, and we might kind of see, certainly not an end to these types of communications, but decreased use and a different use of these types of communications. So press releases are one form of public shaming that OSHA has used and used quite often in the Obama administration. These press releases are posted on OSHA's publicly available website and oftentimes are picked up by local news outlets if the citations are related to a particularly serious or public incident or accident in a certain area. These press releases generally address the citations that are being issued against the employer, and they usually do include a somewhat scathing comment about the employer's noncompliance with OSHA's regulations. As you can see on this slide, During the Bush administration, OSHA used this tool much more sparingly, issuing only about 148 press releases per year, or about 12 per month during that period from 2003 to 2008. However, during the later half of President Obama's first term and through his second term, OSHA issued over 3 times that amount compared to what it had published in that prior 5-year period, or about 463 press releases per year. Comparably, in the first year of the Trump administration, after President Trump's inauguration on January 20th, 2017, only about 45 press releases were issued, or about a tenth of what we saw on average during that prior 5-year period. It's important to note that during about the first 3-ish months of his presidency, there were actually no press releases issued related to an enforcement action or citations being issued. And the amount of press releases did pick up toward the end of 2017, with the biggest months being November and December. And those months had about 10 each of press releases on, the issuance of citations and these enforcement actions. But the numbers still fell well behind the press releases administered during the Obama administration. And even in those months, more closely reflected the number of press releases that we saw coming out during the Bush administration. Related to this topic, it's important to note that President Trump's nominee for the Assistant Secretary position, Scott Mugno, did express his belief that there is some place for these types of publications to increase awareness during his hearing before the Health Committee. But it's unclear at this time how he or even the agency generally would expect that this policy is implemented. Therefore, we predict that OSHA will likely continue to use press releases, and probably more often in the upcoming years than it did in 2017. But this will still likely be substantially less than during the Obama administration and a less significant tool in this regard. It also appears that OSHA is using a higher penalty threshold as the trigger for press releases. In the Obama administration, OSHA generally was using around $30,000 as the threshold for putting out a press release related to the issuance of citations or enforcement action. But obviously, as the press releases have been much less frequent during the Trump administration so far, it does appear that this threshold penalty level has increased. And then just quickly here, some other forms of public shaming that we've seen. The first is shaming of an employer who qualifies for the Severe Violator Enforcement Program, or SVEP. Under SVEP, employers experience public shaming in a couple of ways. First, with a particularly egregious press release in which the agency will identify the employer as a severe violator, again, at a point before the employer can actually defend themselves or evidence has been presented to support the allegations. And there's usually at least one inflammatory quote in the press release from a Department of Labor official. And then the second form of public shaming related to the SVEP program is being included on a publicly available log of those employers that OSHA has assigned as severe violators. So in the first year of the Trump administration, we have seen these tools continue to be used by OSHA, with new employers being placed on the SVEP log and some pretty strong language used in press releases related to severe violators. However, we do continue to believe that this will be one of the policy initiatives that is revamped by the Trump administration over the remaining 3 years of the administration. We think the most likely change would be to revise the policy to delay announcement of an employer into SVEP until a resolution of the citation has been reached or a decision has been made, and then more generally to ensure that SVEP really only includes those it's truly intended to include, those so-called bad actors. OSHA may also consider, getting rid of the program or stopping use of the program, but we think that that's pretty unlikely, even in a circumstance where we are focusing more on compliance assistance from the agency. In addition to the SVEP program and public shaming associated with SVEP, The rule, the final rule requiring electronic submission of injury and illness data, also requires OSHA to publish the data received from each employer required to provide that information under the standard. So in this way, OSHA would make public the injury and illness records of particular employers that are covered by this rule. However, under the Trump administration, as Dan discussed a bit earlier, OSHA has established its intent to revise this rule, particularly by only requiring employers covered by the rule to submit 300A data, and this would only provide a summary of the incidents over the prior year, as opposed to the specific details that are given in the 300 log and the 301 report. At least at this time, it appears OSHA is still intending to publish the data that is provided by employers as a main thrust of its potential change to the rule is to protect personally identifiable employee information that may be revealed through 300 log and 301 report data. Potential revisions would significantly limit the data that would be obtained and made publicly available on OSHA's website. OSHA has also revised its practice for publishing worker fatality data. Under the Obama administration, there was a running list of worker fatalities near the top of its homepage, and this information would include the worker's name, date of death, as well as the cause of death. It included all fatalities that were reported to OSHA, regardless of whether there were citations or violations associated with the incident that may have resulted in the employee fatality. In August, this running list was taken off the homepage. It's still publicly available on OSHA's website, but there would have some navigation of OSHA's website to be able to find that data. Furthermore, now the available list does not include fatalities where the employer is not actually cited. This further evidences that the Trump administration is likely moving away from public shaming as an enforcement tactic, as fatalities linked to a specific employer are no longer being shown front and center on OSHA's website, and the information that will be available related to those fatalities is more limited. And then finally here, just the last quick point, OSHA's quick take newsletters and tweets in the past have been really heavily focused on enforcement, but recently during the first year of the Trump administration, we have seen that change, and these quick take newsletters and these tweets are less enforcement heavy, enforcement focused. So with that, I will turn it over to Andrew to address the topic of state OSHA programs.
Thank you, Lindsay. I'm going to shift focus and briefly discuss the state OSHA programs. Most of us think of Fed OSHA or perhaps Cal OSHA when we think about workplace safety matters, but there are quite a number of different state plans to consider. In fact, there are, turning to the next slide, there are 22 states and territories that have Fed OSHA, or have state plans, and in some ways meet the Fed OSHA standards, but in many other ways exceed those Fed OSHA requirements. In order to qualify as a state plan, the state must have a safety program that's at least as effective as the Fed OSHA standards. And Cal OSHA is an example of one state that has in many ways far exceeded the federal OSHA standards and become a more challenging enforcement state to deal with. So there are 22 states and territories that have their own state plans that apply to the private sector. There are 6 states and territories, including Illinois, that have their own state plan, but it only applies to the public sector, to state workers, essentially. And then you have some states that have been particularly aggressive, such as the blue states of California, Washington, and Oregon. We practice in California as well as Washington and Oregon, and all 3 states have tended to be quite aggressive on the enforcement front and have enacted their own rulemaking that has differed in some respects from Fed OSHA. I wanted to address some of the California-specific issues. California has engaged in rulemaking, as an example, predating Trump, as well as other more kind of progressive state plans. And I think you'll see that there was quite an aggressive kind of rulemaking enforcement tendency pre-Trump that may continue. Will certainly continue in California, reflexively to the lack of action in D.C. On the regulatory front, at least compared to what we've seen under the Obama administration. But in California specifically, we will expect to see a number of new rules in the coming year. We will go over these developments in more detail later in the year in our Cal OSHA specific a webinar that I invite you to attend. But just very briefly, as Fed OSHA halts rulemaking over workplace violence, specifically moving it to a long-term action, California has not only enacted workplace violence rules for healthcare this last year that impose a number of onerous requirements on healthcare employers, but it has also expanded or seeking to expand its rule to cover all industries, and that's in the works right now. We also have Cal OSHA looking to regulate ergonomics for hotel workers, to protect workers from back strains and other musculoskeletal problems. And this is being considered as Fed OSHA has abandoned ergonomic regulations. We also have in California many other state plans, injury and illness prevention programs, and which contain a number of requirements. But California specifically is seeking to expand those requirements to require employers to share their injury and illness prevention programs with workers upon their request. Another significant development in California was that there was a mandate by the California legislature to compel the development of regulations addressing heat illness prevention for indoor workplaces. We've already had on the books heat illness prevention requirements for outdoor workplaces, and they're seeking to expand to indoor places, and that is been in the works for quite some time. And it appears that this year we will see standards, and there's quite a bit of consternation by employers about how practical this will be in terms of applying to the common workplace. And then in terms of recent actions by Cal OSHA in the last year, we have had a couple new regulations that have had a significant impact on employers in California. One is the new repeat violation rule. It was enacted last January, effectively conforming California to the Fed OSHA standard. Previously, the benchmark for a repeat violation was whether the violation occurred within the same facility previously and again. And now the benchmark is whether the violation, the previous and the successive, occurred within any facility operated by the employer within the state. Cal OSHA has also revised the look-back period from 3 years to 5 years in terms of measuring the two violations to determine whether there's a repeat. What is interesting here is California has moved forward in this one way in which it was not as strict as the Fed OSHA standard, but if Fed OSHA decides to scale back their repeat violation rule, you'll most certainly see California remaining in place and not following Fed OSHA. So anytime, typically when you see California moving forward on something, if the Fed OSHA moves back, you're not going to see Cal OSHA take a less aggressive stance. In fact, they will likely continue the more regulatory heavy position. In terms of the civil penalties, Cal OSHA does not neatly conform to the Fed OSHA penalty structure in some ways, such as with serious violations, the penalty in California is higher. It's $25,000 is the maximum penalty in California, which is higher than the Fed OSHA standard. There were a few respects in which the Cal OSHA standard, after the increase in the Fed OSHA standards in recent years, remained behind Fed OSHA. That has changed, and as of September of last year, Cal OSHA has increased the general, willful, and repeat violation penalties to conform at least as to the penalties under Fed OSHA as of August of 2016. And in any case, we'll discuss more of these developments and what to expect in California at our webinar later this year.
All right, thanks, Andrew. And then our 10th and final topic for today is just a quick rundown of some significant deadlines and important dates in 2018. So based on the time, I won't really spend too much time talking about this. I do want to note that the first significant deadline for the beryllium rule is March 12, 2018, which currently most provisions of the beryllium rule have this compliance deadline. However, we are aware of settlement negotiations that are ongoing with the agency that will likely result in an enforcement delay, assuming settlement is actually reached. So there'll be more news on that probably over the next couple of weeks, and we will definitely stay on top of it and keep you informed. Then the next series of dates here all relate to the silica rule. This rule has gone into effect. And in general industry and maritime, you'll see that this June 23rd, 2018 deadline is for most of the compliance obligations under the standard, as well as when employers have to begin to offer medical exams to employees who qualify. And then finally, with the construction standard, most of the obligations already went into effect in September 2017. But this last requirement to comply with methods of sample analysis, that deadline is June 23rd, 2018. And then some last few deadlines there. The next electronic data submission date is July 1st, 2018. Right now, it is limited to just 300A data, even for establishments with 250 or more employees. And that, again, is related to OSHA's intention to reevaluate the rule, potentially remove the obligation to provide 300 and 301 report data. So right now, it's just the 300A summary data that will be due July 1st, 2018, and we'll keep you apprised if there's any change there. And then these last two deadlines in November, certification of crane operators by November 10th, 2018. This deadline has been pushed at least one time previously, but right now it's November 10th, 2018. And then finally, November 19th, 2018 is the relevant deadline for some requirements under the new walking working surfaces standard for fixed ladders that are 24 feet or greater.
All right. So we've slogged our way through a top 10 list. I think our lesson here is that next year maybe we'll do a top 5 list. I appreciate everybody sticking with us today for a very long program, but this is one of those weird periods where you're, between two administrations, there's a lot happening. There's a lot to cover, and that's why we think this year's webinar series is going to be a great one. We hope you join us for the rest of the programs. This year. You see the list of those in front of you, and likewise, make sure you're staying tuned to our OSHA Defense Report blog, www.oshadefensereport.com. We will try to keep up to date and keep current with all the breaking news that's going on in the OSHA arena. I do see a few questions. I'm going to address a couple of those real quick, but I know I've kept you guys for a really long time. So if you do have questions, or if we don't address any of your questions, please don't hesitate to contact us, reach out by phone or email, and we're always happy to talk about those issues. A good question here about I think Aaron talked about the perhaps a curtailing of the national emphasis programs, so we'll likely see some of those retired over the course of the administration. The question here is, what do we expect for the ChemRef, the Chemical and Petroleum Refining Process Safety Management National Emphasis Program that just went into effect in January and is just kicking off right now. The first inspections under that program are just starting. My guess is that that's not going to be one that gets cut or cut prematurely. I think it will run its course, and the reason I think that is that it was initiated after Secretary Acosta was put in place. And while we don't have an assistant secretary for OSHA, the decision to proceed with that program was made already with the the secretary level Trump appointees and a deputy assistant secretary. And I think that will always be a focus on chemical manufacturing and petroleum refining. Even as OSHA might contract somewhat in its enforcement, it still pays attention to those areas where there's potential for very significant events, like in the PSM covered workplaces. So my expectation is that that's not going to be cut prematurely, and that the big change about that program is that it sweeps in the refineries for a round 2 of NEP inspections. And my guess is very likely all of the refineries in the country will be visited under this program before that is retired. Let's see what else we have here. A question about, I thought I saw something about electronic record keeping. Oh, there's a good question here about the regulation by shaming topic. Has the definition for press releases differed between administrations? And I think what the question is, as sort of the threshold for what triggers a press release, has that changed? And it absolutely has. I mean, during the Bush administration, what triggered a press release was a significant case, a penalty over $100,000, or a fatality case, or something very sort of interesting, peculiar, or new might also get a press release. During the Obama administration, that penalty trigger for a press release was dropped down to as low as $30,000, which is a pretty ubiquitous enforcement action, which is why we saw 4 to 5 times as many press releases issued across those two administrations. My understanding now is that the threshold is again in that $100,000 range. It might be $80,000. It's not set in stone. I think that's going to be a decision that will be made once an assistant secretary is in place. But what we've seen, they were cut off completely for the first few months after President Trump's inauguration. Once they started again, it was really those, it seems to me that it's only matters that have been over $100,000 that I've seen, those types of press releases. So I think we'll cut it off there, because you guys have given me more of your day than I'm sure than anyone expected, and I'm very grateful for that. I do encourage you to reach out if you have any questions. Shoot me an email, give me a call, or reach out to any of my colleagues. This was one of my favorite programs of the day, of the year, to get our whole team together to really, I think, show off to you all what a deep bench we have. We're very proud of the team we've put together here. I think a really special OSHA practice. There's not many out there in the country that have this significant a group of individuals who are focused essentially exclusively on workplace safety and health. And we're very proud of the team we've put together here, and very pleased to be able to put this program on for you. So thanks for joining us, and we look forward to a really good year of webinars again.